Hey folks, we're back. So let's look at principles of agency. Now, we have looked at business organizations, have we not? So we have an idea of how you can construct a business. And now we're going to look at some relationships that exist within the business structure that allow individuals to kind of contract things out. And then we're going to look at contracts after that. So let's get started. It's common to have one person act on behalf of another in dealing with third parties. Three types of relationships are going to be discussed: principal-agent, employer-employee, employer-independent contractor. So, principal and agent. An agency relationship exists when one person called an agent is authorized to act on behalf of and under the control of another person called a principal. The person the agent deals with is known as a third party. So we do not have any type of employer-employee relationship because we see that's something separate. So you're a funeral home owner and you want to increase your call volume. So you decide to work with and hire someone through a marketing agency to improve your visibility and generate some calls. You authorize that individual to take reasonable steps to increase your call volume and to enter into transactions, maybe not more than 2 transactions, not to exceed a total cost between both of them of $15,000. So that individual has essential, for the most part, and for the sake of this discussion, carte blanche, okay, to go out, negotiate at least 2 deals who, by the end of the day, cannot total more than $15,000. And the people they are dealing with will be the third parties. And when a principal authorizes an agent to enter into a contract on their behalf, the resulting contract is between the principal and the third party. The agent is not a party to the contract. They cannot be sued for the breach if a breach does occur. Only when the agent acts without authority or fails to disclose the existence of the agency relationship can the agent be held liable on the contract by the third party. So same situation. Your now marketing rep goes into a sign shop and says, I need some signs. My name is Tom. I work for B2B Marketing, and we are representing Smith Funeral Home, who's authorized me to buy some signs for them. So you look at the signs, you like what you see, he writes up the bill of sale and contract, and he signs as the agent responsible for facilitating the contract for the funeral home. We will say for the purposes of the discussion that it does not exceed any of his appointed boundaries. The contract exists now between the funeral home and the sign vendor because the principal, the owner, has authorized this individual to go out and do this on his behalf. It'd be a slightly different situation if Tom walks in and says, hey, I need to buy some signs, and spells out the funeral home name on the sign and all this other stuff, then signs the purchase order and says, we'll send you the check. Well, we haven't discussed contracts yet, but you view a contract from the perspective of a third party observing the transaction. Third party, okay? And here we see an individual walk in, has not made any disclosures whatsoever, ordered some signs, and said, I'll send you a check. Everything would lead a person to believe that this would be an individual buying some signs, irrelevant that the signs have a different funeral home's name on it. Who knows what's going on there? It's not the vendor, the sign maker's responsibility to figure that out. So in this case, either the funeral home can be held liable because it's undisclosed principal. We're going to see that in a second, okay? Or the sign vendor, the marketing rep can be held liable if there is a breach. So in this case, we do have that undisclosed principal. The third party deals with the agent, is not aware of the agency relationship, so the privity of contract, the contractual capacity exists between the third party and the agent can be held liable. And if that check doesn't come, the sign company can go after the agent or the funeral home. So if the funeral home truly did not want to be disclosed, why you would be sending someone else to buy signs with your name on it if you didn't want them to know it's for your business, that would be a logical jump, wouldn't it? Okay? You can create a dummy corporation. You create an incorporated fictitious body. Okay? Remember, a corporation is a fictitious individual. You create someone that acts as the principal for your agent. And this is exactly what Walt Disney did back when he was buying land until people caught on for his theme parks. An employment relationship exists when one person, called an employee, performs services under the direction of another, called an employer. This is an evolution of the old English common law concept of master and servant agency. Employees may also be agents if they've been authorized to enter into contracts with third parties on behalf of their employer. So let's look at some of these things. Is it possible, do you think, that an employee can be both an agent and an employee depending on what they do at the funeral home? So a funeral director, they sit down, they meet the family, right? Are they entering into a contract? I would hope so. It's a funeral contract. So we'll say for the sake of argument that a contract will exist. Who is the contracting parties? The employer, the funeral home, and the client, the third party. So in that transaction, in that contractual instance, you are also being an agent of the funeral home. And you would be held, you could be held, to slightly different whatsoever than just an employee. But now what happens, if another funeral director meets with the family, and you end up taking the service out, are you an agent at that point? Well, you're not really contracting anything, are you? So there you have a much truer idea of the employer-employee relationship. And you can see that your actions and what you do can determine the type of relationship you're in and what rules may apply. Employers are liable for the tortious actions of their employees if the injury occurs during the scope of their work. We're going to see later on, under tort liability, a doctrine called respondeat superior, and how that applies. Independent contractors, different from employees, in that they perform services for others, but not under the employer's control. People who have independent contractors perform work for them, and they don't withhold taxes for them. They're not responsible for their wrongdoings. So there are some perks to that if you are an employer. There are some disadvantages to that if you are an employer. So how does this work? What's the big distinction? And we will look at employment law briefly when we look at the mortuary law textbook by Gilligan, because there is a whole chapter dedicated to wage and hour laws. So as an employee, if you are running down the street, you work at a funeral home, full-time, you're not licensed, and you have your very expensive electronic device in your hand that allows you to take pictures, access the collective knowledge of humanity from anywhere it has a signal. It allows you to check your heart rate. It even allows you now and then to actually communicate with other human beings. And you are choosing today to use your expensive device to catch Pokemon. And while this individual on his day off is trying to catch a Bulbasaur, he jumps someone's fence. And by doing so, breaks the fence. Can they sue the funeral home? Not so much, right? He's not acting within the scope of his work. So the fact that he is an employee of a funeral home does not mean that that tortious activity, the destruction of the property, the conversion, the trespass onto the land, that's going to be applicable to the funeral home because it's not within the scope of their work. What if they're an independent contractor? Same result, doesn't matter. Even less in control. And we will look at those rules a bit more in depth, again, in the mortuary law section of this course, just because of the fact it fits better with the wage and hour laws. So what type of agents are out there? We have a general agent, which is one who's authorized to conduct all of a principal's activity in connection with a particular business. A special agent is one who is authorized to carry out a single transaction or to perform a specific act. So, a manager of a facility who is responsible for all the duties of everyone may be able to do anything in connection with that business. However, a special agent, we'll say for the sake of argument, someone who purchases, their sole purpose for the organization is to buy things and ensure the quality of what they're buying meets the needs of the business. If they were expected then to turn around and do quality control for a combined product where the components of what they purchase singularly are combined into some new item, they may not be authorized to sell that to somebody else. That would be the role of a salesperson, for instance. If goods are given on consignment, they're left with the seller, or consignee, by the owner or consigner. If you think these sound familiar, been looking through the glossaries, you're right. They're essentially a bailer and a bailee, and we will cover bailments, and you'll know more about that. Agents are usually given the authority either in writing or by speech, and they're given their duties expressly. They know what they're supposed to be. So express authority is authority that is given explicitly. This is common when using an instrument known as a power of attorney. When a power of attorney is used, the agent is referred to as an attorney in fact. Implied authority is a type of authority that the agent customarily and reasonably needs in order to perform incidental functions that enable the agent to accomplish the overall purpose of the agency. So an express authority would be you will handle the transactions of real property, of any property that I own within Miami-Dade County or the city limits of New York City, A or B. Well, the implied authority that goes along with that would mean you'd be able to make phone calls and negotiate. You would be able to sign your name to certain legally binding documents and all the things normally associated with that. So you don't have a laundry list of things in your power of attorney that say exactly what you are limited to do. Well, what if you only wanted the individual, only wanted the individual to verbally negotiate but not sign or do anything else? You would expressly put that in their power of attorney. You are expressly authorized to negotiate orally any contract, but final ratification must be approved by Apparent authority comes about when a principal, through some act, makes it appear that an agent has authority when none exists. This leads to agency by estoppel, because the principal will be stopped or estopped from denying that an agency relationship existed if he or she attempts to do so. So if you try to be slick about it, if you try to be slick about it, apparent authority makes it appear that an agent has authority when none exists. You will be prevented from saying, oh yeah, I tried to be slick. They didn't really have authority and I wasted everyone's time. Again, this has to do with contracts. The law likes to find contracts. When an agent acts on behalf of a principal without an authority to do so, but the principal later approves of the act, it's known by agency by ratification. So they did not have the ability to enter into a contract, only orally negotiate the terms of something for approval elsewhere, and actually approved it. And it was such a hell of a deal, the boss thought it was a great idea and let it stand. That would be an agency by ratification, as an example. And sometimes agents completely drop the ball. They act improperly, and this leads to one of three terms. Misfeasance, the improper doing of an act. Malfeasance, doing of an act that should not have been done at all. And nonfeasance, the failure to do an act that should have been done. Thank you for your attention, folks. We will see you next time.